Hello and welcome to the lesson on protection of the rights of women and children with HIV/AIDS under the Indian law. Friends, the response of Indian law in the matter of promotion and protection of the rights of women and children with HIV/AIDS is poor, while the situation is alarming in the case of women and children, as they are the vulnerable section of the society and can become easily entangled by the spread of the dreaded epidemic. It is the civilized norm of a society where women and children are given special protection and care in every respect, including prevention of the spread of the said virus. And here we refer to the constitutional provisions in India. The Constitution of India under Article 15 Clause 3 has laid down that the states can make special provision for women and children, and it is one of the fundamental duties of the Indian citizen to renounce practices derogatory to the dignity of women. Further, it is the bounden duty of every state under Article 39 Clause F to direct its policy towards securing that children are given opportunities and facilities to develop in a healthy manner and in the conditions of freedom and dignity, and that childhood and youth are protected against exploitation and against moral and material abandonment. It is believed that HIV/AIDS had first came to India in the early 80s, though the first HIV infection was detected in the year 1986. The virus has spread throughout the length and breadth of the country, including northeastern states. In the state of Manipur, the HIV has created an epidemic situation amongst the injecting drug users. HIV in many ways has become a destabilizing factor for the Indian community because it brings stigmatization, discrimination, fear and hopelessness both for the individual family and the society. It often violates the basic human rights of the affected person, namely privacy and confidentiality, honor and human dignity. As the present lesson concerns protection of the rights of women and children with HIV/AIDS, it is imperative to refer to legal provisions that may be relevant to the women and children living with HIV/AIDS, and also to refer to the role of the judiciary in regarding to the emerging problem. As at present, there is no specific legislation on the subject. Let us come to the criminal law and transmission offences. The old law, which is still in force in India, deserves a mention in the present study, that is Epidemic Diseases Act 1897. Considering that HIV is also akin to a spread of an epidemic, the provision of the law is relevant in the present lesson. Under the Act, the state government is to take action in case when the state or any part of it is visited by or threatened with the outbreak of any dangerous epidemic disease. The state may take such measures such as section of the persons travelling by railway or otherwise, including the act of maintaining segregation in hospitals, provisions for temporary accommodation or otherwise of any person suspected. The central government may impose quarantine rules for inspection of any ship or vessel or aircraft leaving or arriving at any part of India and may detain any person if it feels necessary. Any person disobeying any regulation made under the Act is punishable under Section 188 IPC. The state government or the central government shall decide as to in what manner and by whom any expense incurred, including compensation, be defrayed. The Indian Penal Code 1860 provides under sections 269 and 270 to punish any person doing any malignant act causing spread of infectious disease which are dangerous to the life of another by imprisonment for a term of 2 years or fine or with both. Section 271 of the code punishes a person for disobedience to quarantine rule. Even any person doing any act with such intention or knowledge that if he by that act will cause death of another shall be punishable under Section 307 of the code for attempt to murder. A recent legislation regarding children is the Protection of the Children from Sexual Offences Act 2012. The Act is passed in order to protect the children from the offences of sexual assault, sexual harassment, and their exploitation in promoting pornography. A child is defined as a person below the age of 18 years. Under Section 5, Clause J, Subclause 3 of the Act, whoever causes penetrative sexual assault on a child which inflicts the child with the human immune deficiency virus is punishable with imprisonment for a term which shall not be less than 10 years but may extend to the imprisonment for life and shall also be liable to fine. But these laws can, at the most, punish an infected person who does any malignant act or who violates any quarantine rule. By these laws do not help in the prevention of the spread of the HIV/AIDS. The present problem involves many legal issues, viewing it from the human rights perspectives of women and children. Some of the issues that require to be addressed by the law are: firstly, the rights of women and children within the family. Secondly, the personal laws and positive persons in the matters relating to marriage, divorce, maintenance, etc. Thirdly, rights to medical help. Fourthly, sex workers and spread of HIV infection. Next, termination of pregnancy. Next, privacy and confidentiality, and also discrimination. In spite of the fact that adequate laws are not yet made in those specific areas, emerging problems do come up before the courts, and the courts are to solve the problem with reference to the protection of the rights of the affected persons and their dependents, by reference to the principles of justice, equity, and good conscience. Though the cases are not clear examples of the involvement of the protection of the rights of women and children who are affected by HIV/AIDS, the cases are related incidentally to their protection of the rights, and hence a review of the cases is imperative. In a case, Mr. X versus Hospital Z, which is reported in AIR 1999, Supreme Court 495, the appellant Mr. X proposed to marry one Miss Y, which was accepted, and marriage was fixed for December 12, 1995. But the marriage was called off on the ground of blood tests conducted by the respondent hospital, in which the appellant was found to be HIV positive. The marriage that has been settled was subsequently called off, as several people, including the members of the appellant's family and the persons belonging to the community, became aware of the appellant's HIV status. The appellant sued the doctor as well as the hospital, who were responsible for leakage of the information. The appellant first approached the National Consumer Disputes Redressal Commission for compensating him against the respondent for deficiency in service. The ground was that the information, which was required to be kept secret under the medical ethics, was disclosed illegally, and therefore the respondents were liable to pay compensation for the loss caused to him due to their negligence. The complaint before the National Commission was dismissed. Therefore, the matter was brought in appeal before the Supreme Court, where the appellant contended. First, the principle of duty of care is applicable to persons in medical profession includes the duty to maintain confidentiality, and since the duty is violated by the respondents, they were liable. Secondly, the regulation framed by the Indian Medical Council, which has got statutory force, provides the rule against disclosure of the secret of a patient that has been learned in course of exercise of their profession. It is contended that the doctor's duty to maintain secrecy has a correlative right vested in a patient, that whatever has come to the knowledge of the doctor would not be disclosed. The court did not agree with the appellant's contention. The question which arose in that case is as to whether the physician who conducted the test on the appellant is duty bound by the Hippocratic oath as well as by the Indian Medical Council regulation not to disclose the secret of a patient, or he has some duty with respect to the healthy women who has to be infected and who can be infected if he does not disclose the confidentiality. The world at large has a right in respect of doctors to save them from such dreaded disease. The court further observed that although the duty to inform about the ailment rests in the patient himself, yet a doctor would not be breaching his Hippocratic oath about secrecy if he informs about the disease to the prospective wife of the patient. In the said case, the crux of the matter was as to how to balance the conflicting claims of the right to life of a would-be wife and the right of secrecy of a patient undergoing treatment. It becomes more important in view of the fact that the medical science is still at a loss to find out the way for cure of AIDS. Justice Sagir Ahmad has analyzed the provision of the English law on the subject. The General Medical Council of Great Britain in its guidance on HIV infection and AIDS, has provided as when diagnosis has been made by a specialist and the patient refuses permission to be informed of the result, that request for privacy should be respected. But occasionally, there may be cases where the doctor may wish to disclose a diagnosis to a third party, and the only reason for which that is when there is a serious unidentifiable risk to a specific person who, if not so informed, would be exposed to infection. Mr. Justice Ahmad has elaborated the relevant provisions of various matrimonial legislations such as Section 13, Subsection 1, Clause 5 of the Hindu Marriage Act 1955, Section 2 of the Dissolution of the Muslim Marriage Act 1939, Section 32 of the Parsi Marriage and Divorce Act 1936, Section 10 of the Indian Divorce Act 1869, and Section 27 of the Special Marriage Act 1954. Under these provisions, a divorce is lawful by a party to the marriage that the other party is suffering from virulent form of venereal disease. It has been tried to establish that a person who is suffering from HIV can be termed as the worst kind of the venereal disease and consequently has no right to marry and enjoy sexual pleasure that may be said to be guaranteed under Article 21 of the Constitution of India. The judge opined that what is talk of enjoying fundamental right, such persons are liable to penalty under the Indian Penal Code. In a case, the court informed that the patient has a right against the doctor not to divulge his privacy and confidentiality, which impairs his dignity. At the same time, the world at large has a right, in respect of the doctors, to save them from such dreaded diseases. In the instant case, the view of the court is that the patient has a right to enjoy his life, and a healthy woman has also a right to life under Article 21, not to die from AIDS. Let's come to another case, decided by Bombay High Court. The Bombay High Court has also faced a case of claim of the rights of the HIV-infected person not to be terminated from his job. In that case, a person working as a casual laborer in a corporation was tested HIV positive. Then and there, a termination order was passed against him to leave his job on the ground that his HIV status. The Bombay High Court in MY of Bombay Indian Inhabitants versus MSZY reported in AIR 1997 Bombay 406 order for reinstatement of that HIV positive worker and for payment of the back wages. The judgment was silent as to what measures that will be taken for the wife and 2 children of the affected worker, and they are left completely at their own risk. In another case before the Bombay High Court was AC and others versus Union of India, read petition number 791 of 1989, where the court indicated that right to marry may be undisturbed if the parties are disclosed about HIV status and they give full, free and informed consent. So friends, we can conclude by mentioning that the government of India does not have specific laws to protect and promote the human rights of women and children living with HIV/AIDS, in spite of the fact that under Article 15, Clause 3 of the Constitution, the states are permitted to make special provisions for women and children. the problem is emerging and spreading to the general population. Education must be imparted to make the women and children known about HIV/AIDS. In giving education, a mandatory legal provision is needed as to in what manner and by whom and at what places the education is to be imparted. That will be addressed to women and children. A provision would also be necessary for fund for the purpose. The course content should include the question as to how HIV is spread and how it does not spread. Women are more vulnerable to HIV. Moreover, women are also often unable to refuse sex, even if they don't want it. Women must be made sensitive about possible prevention of her HIV being transmitted to her child when she becomes pregnant. India has no existing anti-discrimination legislation which can cover discrimination on the ground of HIV/AIDS. There is no health legislation in India to address the issues involved in the present context regarding women and children. A law relating to the issue is expected in the near future, and the activities of the courts will also become active when legislations exist in the matter. So friends, with these few words, let us conclude. Thank you very much. Have a good day.